So we have made it absolutely clear that we agree with the substance of this
Honourable
part.
Judith Collins.
Mr Chair, I'd like to take the opportunity to address some of the issues that have been raised tonight. Some of the issues that Mr Chevelle mentioned and raised, when I have to say in a pretty patronising way, frankly, and I thought it was... but having said that, it was significantly better than the contribution from Mr Andrew Little, which I have to say resembled a plea in mitigation more than anything else. So one of the issues that Mr Chevelle has referred to is that it's apparently now the age of Google. Well, it's been like that for a wee while. But we also have a situation where the Law Commission has considered the issue of jury anonymity in its 2001 report, Juries in Criminal Trials, which I'm sure he's read, and if not will, in that the report was made, or the comment was made, that some international jurisdictions have implemented laws allowing, or in some cases ensuring, anonymity. It's using unique identifiers rather than names. And that would be something which would help in terms of identification, obviously, for jurors and their protection. However, the Commission did not recommend any such provision in New Zealand on the basis that it could only be justified if there was a genuine threat to juror safety, so in terms of that particular issue. But the Law Commission also noted, and I think this is very important because, of course, juries have to look at the facts, they have to be fairly dealt with, they have to be able to deal fairly with the issues before them. But the Law Commission also noted that there is some evidence that juror anonymity may affect jury verdicts, with anonymous jurors far more likely to convict. And I think that's something that we should take seriously, that in fact jurors generally, and I think that's the experience of most people who have had anything to do with them, take their job extremely seriously and do their very best. Sometimes when we only see media reports about cases, we might wonder as to how they came to those decisions. But actually they've heard all the evidence. They and the judges are the only people, apart from defendants and the lawyers, who have heard all the evidence, and they come to their decisions having considered it very fully. But, however, we do know that there has been this problem of how do we provide the lawyers for the defendants, or lawyer for a defendant, with information that can help then decide whether or not a juror might have a conflict of interest or some prejudged comment that they've made, all those sorts of things, and at the same time to do what we can to protect the juror. A comment was made by Mr Chevelle's suggestion. It was around the fact that we could make an offence to Google or to try and contact someone or get their information without lawful excuse. So that was pretty much what you were saying, wasn't it, Mr Chevelle? Well, actually, the people we're talking about who could be so dangerous to jurors are sometimes murderers. I really don't think they're going to worry too much about a fine for contacting or trying to get information on Google. So I don't think that's going to work. But I think that the solution that was come up with is a very sensible solution. In fact, the Select Committee felt so too, that it is in fact balanced. It does consider the right to a fair trial, and at the same time it enables the jury list information that has particular information around the juror's address information can be designated as protected particulars so that it can in fact be dealt with by way of a self-represented litigant or defendant who would actually not get to see all those particulars. A lawyer would be appointed to look at those for that defendant. The lawyer would be able to certify to the judge that they didn't give them the copy of it, that they brought them back, and they in fact enabled someone to a defendant to be able to say that person there is someone who used to go out with that witness who's going to say this about me. I mean, that's the sort of thing that they should be able to do. So it is actually a balance. It doesn't solve every situation that might occur. It does not future-proof everything, because actually that's not how the law works. The law is not so certain. It is in fact a balance between the right to a fair trial and also for jurors to be able to feel that they are safe, that they can be protected, and that they will in fact want to serve their service as jurors.
Honourable Leanne Dalziel.
The Minister